David Clark.
Mr Chair, this bill is an interesting bill. Labor will support it. We have an interesting situation where there's no regulatory impact statement that's been prepared because it is expected that there will be no impacts on businesses, individuals or not-for-profit entities, or at least, if not no impact, then only very minor impacts. And this is an unusual situation because it is usually the case that we have to consider those matters in great detail. According to Cabinet papers, last year there was an incident where a self-represented accused corresponded with persons whose names and addresses were on the jury panel for this trial. This raised concerns about the safety of jurors, and it was decided to amend the Juries Act to restrict access to jurors' address details. This bill is an example of, in that sense, of the government's reactionary approach to justice issues. It would have been nice to see a proactive step taken to ensure this matter didn't occur in the first place. Now, I'm sure that the government will, in response, suggest that perhaps previous governments could also have acted on this matter. It is something that could always be claimed, but it certainly currently falls in the lap of the current government to make amendments in this fashion. We will support it because, as I say, it's not particularly controversial that we should be amending this matter, but it would have been good to see a more proactive approach taken in the first place. The bill means, in effect, that defence attorneys and advisers to defendants representing themselves will not be allowed to show addresses to defendants. And they will still be able to see and hear the name in court, so arguably they could still look up the address in the white pages, perhaps, or on electoral rolls. This is a matter which will no doubt tax minds in terms of how we adapt to that situation, but at least, in the very least, we have an approach which seeks, in principle, to restrict access to that information in a way that we would agree with. We agree that defendants having access to jury addresses is problematic. However, we do not think this bill will make any difference because of the example I've just cited. The defendants who want to find addresses will still be able to do so. Currently, the Juries Act already allows people to be exempt from jury duty on the grounds of occupation, business and state of health, physical disability, family commitments or other personal circumstances. They have to satisfy the registrar that they or some other person would be caused undue hardship or serious inconvenience if they were not excused. The registrar must excuse people if they're over 65 years of age, or if they have a religious view that is incompatible with jury service. This bill will allow for that exemption to be excused permanently. So another matter that is addressed by the bill. There are other smaller matters which are picked up, which I have no doubt that other colleagues more learned in this area will wish to comment on. But people in defendants need to be able to have certain information available to challenge the person selected as jurors is something that we know, and this will ensure that the defendant has a right to a fair trial, which is a fundamental right. So the steps taken in this bill will really make sure that some of the loopholes in the Sentencing Amendment Act 2007 are tidied up. Mr Chair, there have been a number of wider concerns with the justice portfolio, and that is why we are concerned that this particular matter is being given attention when other bigger matters, perhaps arguably, are not being addressed. Where this incident has brought the matter of people corresponding with jurors to light and a reaction has been sparked, it's difficult to argue that that is perhaps the most immediate thing or the only thing that needs to be addressed in respect of the justice portfolio. This government has had a reactionary approach, and examples of that are the surveillance bill, the juries bill, and matters around provocation. It is, Mr Chair,
David Clark.
it is an inappropriate use of parliamentary and select committee process and the use of urgency to pass significant justice bills that have not been sent to appropriate committees. And so when we see this bill coming, we see another example of tinkering around the edges, and we think the legislative agenda should have bills that will have an actual effect on the justice system rather than peripheral changes that will make very little change to the overall nature and problems in our justice system, Mr Chair. We have in New Zealand a real problem with a growing prison population who we all end up paying for, and a lot of these people in prison are there as a consequence of poor choices they've made, but there is no doubt that other factors such as poverty contribute or are correlative factors in offending, and so we would like to see from our side those other factors also addressed. We are not happy with the growing gap between rich and poor in New Zealand, and we would like to see the big issues in the justice sector addressed as those wider societal issues should also be addressed, Mr Chair. I thank you for hearing my thoughts on this matter and wish that this bill does go through, because the little changes it makes are hard to argue against, but wish to lay on record my concern that we're not really addressing the bigger issues in the sector, and as I say, I'm sure some of my more learned colleagues will go into greater details on those matters. Thank you.
Honourable Leanne